I'd like to introduce Brian Walters for those of you who aren't familiar with his outstanding contribution to environmental law. We have some commonalities, NELA and Brian, some seminal experiences, you might say. In 82-83, Brian rafted down the Franklin River to join the Franklin blockade, and Simon would remember that. I think he was part of those activities as a supporter of the Save the Franklin campaign. That was a heightened time of interest in environmental law, and that was in 1982 when NELA was formed. So he would have already been mature, but Simon, Ben, I don't know if Brian was involved at that point, but NELA was formed at that time, and then we later became incorporated. So we were all inspired by that need to save the Franklin River. I did circulate the URL to Wikipedia. I seem to think that people who have very good Wikipedia profiles are selflessly wanting to relieve others of the duty to write obituaries. We hope that Brian is in robust good health, and we are grateful to have his profile so readily accessible. Brian has a long involvement in environmental matters. He was a founding member of the Victorian Greens. He's appeared in numerous human rights and environmental law cases, both at the UN and domestic level. He's been a champion of forestry law matters and rights to protest, so a civil libertarian. He joined the Committee of Liberty Victoria in 2001 when he took Silk, and he served that organisation in executive roles as Vice President and President for many years. He's got a thick skin. He stood as a Greens candidate in Melbourne in 2010. All strengths to you, Brian. Takes courage. In 2014, he published a book on treason, Klaus von Stauffenberg and the Plot to Kill Hitler, so he must be a bit of a history buff. That's available as an interactive book with slideshow audio for iPads and film. So, wow, he's moving with the new digital way of communicating. He led the legal team with TIFF, I think, was involved in that Tarkine Tracks case in 2015-16 in Tasmania, that the four-wheel drive tracks through the Western Tasmanian cultural landscape, those four-wheel drivers were decimating the middens and the quality of the heritage, the artefacts along that track, and he was successful in arguing in the federal court that that should not be open to four-wheel drives. So well done. He successfully challenged the Andrews government's decision to hold children in adult prisons. That's an ongoing issue about the age of criminal responsibility. It's still far too low in most jurisdictions. He was successful in that case. He's run a number of Section 44 dual citizenship matters, and all credit to him. In 2017, he was made an AM, awarded an AM Member of the Order of Australia for significant contribution to conservation, to environment protection law and to human rights advocacy in Victoria. And just before we started, he mentioned that he had been actively lobbying for provisions to allow for protective costs orders. And we know how important those are for public interest litigation matters. The EDO would be well familiar with those types of provisions, and Brian was involved in advocating for those at a federal level. Like my husband, Brian is also a poet, and in 2019, his volume Angels Like Laundry, there's more prosaic than things my husband writes about, it was launched by Mark Tredenick, who's another poet. He's got another poetry book, Brink, published in 2020. So he's kind of like a Renaissance man. We're delighted that he's going to be presenting to us today. And I'd like to hand over to you, Brian. Thank you.
Well, thanks very much. Thanks for that generous introduction. I'm speaking from the lands of the Dja Dja Wurrung peoples, and would like to pay my respects to their elders past, present and emerging. And it's great also to see some familiar faces and many people I greatly admire in our meeting today. At all levels of government, Australia has a range of statutes, regulations, bylaws, standards, codes of practice, principles, international treaties, and other laws designed to protect the environment. A law without a practical remedy fails to serve its purpose. Such a law also brings disrepute, I would argue, on the law as an entity. There are many practical obstacles to enforcing environmental laws in Australia, and I want to give a few brief case studies, perhaps starting here with the trivial, but I think encapsulating what often we experience. Many years ago, my brother was bushwalking along the alpine walking track on Mount Erica, part of the Alpine National Park. And he was shocked to see trail bike riders illegally riding through the bush, churning up the mud and causing a great deal of damage. Now, this has long been a national park, that area, and it's long been illegal for trail bike riders to go there. So he took the trouble to go to the Rawson police station, which is nearby, to report the matter. And the policeman there told him he wouldn't do anything about it. He didn't support the ban on recreational vehicles in the area, and he wouldn't enforce it. And in microcosm, that's the problem with many of our laws designed to protect the environment. They're useless if those charged with their enforcement won't enforce them. And of course, there can also be an attitudinal problem that they're not real laws. They're not laws like a law against a crime. Well, speaking of crimes, I want to give another example. Orange Roughy was first discovered in Tasmanian waters in the 1980s. It's an orangish red fish. It reaches a length of almost ½ a metre. The skin is poisonous to humans, and its oil is powerful enough to be used as a degreasing agent. Orange Roughy is a long-lived and slow-growing species. They take 20 to 25 years to reach reproductive maturity, and they live for 100 years or more. They're found at considerable depth, hundreds of metres to over 1 kilometre. The meat of Orange Roughy survives freezing and packing particularly well, and there's a strong demand throughout the world for this fish. It's often marketed as sea perch, and speaking for myself, I never buy it. After initial minor catches, Orange Roughy was first commercially fished off Tasmania in significant quantities in 1989. Now, the fish were taken in greatest quantities while they were spawning, and the major spawning site in Australian waters is located east of St Helens at an underwater feature known as St Helens Hill. It's a 400-metre high pinnacle or seamount rising from a depth of 1,000 metres. The fish formed a continuous ring or donut, as it's called, around the mount while spawning. Now, at times other than when they're aggregated for spawning over the winter months, Orange Roughy is sparsely spread over large areas of deeper waters off southern Australia. But when they're aggregated for spawning, Orange Roughy can be taken in large quantities in a very short time. When St Helens Hill was first fished, Roughy were reported to enter nets at the rate of 1 tonne per second. It was a very lucrative species. Because of the slow maturing rate and low reproduction rate of these fish, the stock will take an extremely long time to recover from overfishing. Now, the fishery authorities, that's the Australian Fisheries Management Authority, set quotas designed to preserve the fish. the focus being on the fishing stock rather than preserving biodiversity, but still there were quotas. However, within 8 years, orange roughy was commercially extinct in Australian waters. And the reason for this was systematic, fraudulent under-declaration of catch by fishing enterprises. In the late 1990s and early 2000s, I was involved in a series of cases prosecuting both companies and individual fishermen for false statements to the Commonwealth about their orange roughy catch and conspiracy to defraud the Commonwealth. There were several convictions and some jail sentences, and just for those of you who want to follow up one example, there are dozens of reported cases, but one that I think summarises it is called Brinkman and Dix, number 2, 1999, Tasmanian Supreme Court 65. Now, the cases were complex, and it was due to the dedicated work of a team of police and solicitors that these results were achieved. The work included careful reconciliation of a variety of records, as well as, in some cases, covert filming of the unloading of the fishing catch. But critical in the orange roughy prosecutions was the fact that after each fishing trip, the holder of a fishing licence was required to file returns as to their catch. And our legal system understands the significance of making false declarations and statements. So requiring an active statement of this kind is very helpful for enforcement. I'll give another example. On Easter Sunday 2015, there was no work being done on any logging coupe in East Gippsland. That day, Ed Hill and Joe Henderson entered a logging coupe and conducted a detailed survey of logging operations. And their investigation soon showed that contractors under the control of state-owned logging agency Vic Forests had illegally logged protected rainforest. This was a crime. Hill and Henderson prepared a careful report documented with maps and photographs. And they submitted their report to the Victorian Department of Environment, Land, Water and Planning, or DWELP as it's often called, the appropriate body to enforce the law. Well, DWELP then conducted its own investigation. They concluded that the rainforest had been subject to, quote, unwarranted destruction, unquote. They found that the destroyed forest area was large enough to meet the threshold of protection. They criticised the destruction of the rainforest trees, which had no merchantable value. There was no reason to destroy the rainforest. However, they didn't prosecute or otherwise enforce the law other than to suggest that Vic Forest review its own guidelines. They said that despite their own finding that a crime had been committed, a court might entertain a reasonable doubt, which of course is always true. Now, the story doesn't end there. The department then prosecuted Hill and Henderson for illegally entering a timber harvesting safety zone, even though this was on an Easter Sunday when no one was put at risk. So not only was it left to the community to properly oversee and enforce the laws protecting rainforest, but when they tried to do so, the community members were themselves charged with illegally entering this forest. Now, I travelled down to Orbost to represent these two men. In the result, the charges were dismissed as there hadn't been proper compliance with the requirements to mark out the safety zone. A technical defence, of course, as with so many such cases. And the court wasn't dealing with or able to deal with the substantive justice issues raised. But the sequence of events illustrates a pattern that's all too common. A public affirmation by way of a law that certain conduct was prohibited, but the private reality of one rule for those who seek to protect the environment, but another for those who are exploiting it. Back in 1997 to 1998, I represented Bob Brown. He was then newly installed in the Senate on a charge of obstructing lawful forest operations. There were no such operations being conducted at the time, and he did nothing to obstruct logging. But we were nevertheless able to show that the coup which he attended was not a lawful forest operation at all, as it encroached some 100 metres into a zone protected under the Heritage Rivers Act. And the Heritage Rivers Act had a rather unusual provision which made any instrument which purported to violate the terms of that act void. So all of the logging licences and so on were void because they purported to authorise logging in the Heritage Rivers Zone. That's a reported case, at least the appeal was, DPP and Brown, 1998, Victorian Supreme Court 117. Again, no action was taken to prosecute those who, in fact, breached the law protecting heritage rivers. Rather, the state government passed retrospective legislation to validate the unlawful logging, and they removed the provision in the Heritage Rivers Act which had protected the inviolability of those provisions. There's now been several cases in Victoria in which environmental groups have successfully, and in some cases unsuccessfully, litigated to restrain Vic Forests, that's the logging agency, from conducting unlawful logging operations. In the time available, I'll briefly mention three of them. Environment East Gippsland Incorporated against Vic Forest, that's 2010 VSC 335, a decision of Justice Osborne. Wildlife of the Central Highlands Incorporated against Vic Forests, 2020 VSC 10, that's a decision of Her Honour Justice Macmillan. Vic Forests and Friends of Leadbeater's Possum Incorporated, 2021 FCAFC 66. Now, the first two cases resulted in Vic Forests being restrained from logging. On appeal in the third case, the Federal Court found that though the logging was non-compliant with the legal requirements, and this was likely to have a significant impact on protected species, the logging agency had an exemption from the Epbc Act by virtue of the Regional Forest Agreement. The sequence of cases has demonstrated systemic inadequacy, almost willful blindness of flora and fauna surveys prior to logging, and then no system to enforce potential breaches where they're detected. Now, Victoria does have an Environment Protection Authority, but it's still left to community groups to take this difficult, expensive, and of course risky litigation. I want to talk briefly about the Epbc Act. As was mentioned in the introduction, in 2015 and 16, Tiffany Akerman and I represented the Tasmanian Aboriginal Centre in Epbc litigation against the state government over its plans to open four-wheel drive tracks through the protected Western Tasmanian Aboriginal cultural landscape, without approval from traditional owners and without seeking approval from the federal government under the Epbc Act. That litigation was in the result successful, and the proposal has this year been finally abandoned, and I see in the audience Adam Beeson, who was critical in this litigation as essentially conducting it from the outset as the relevant solicitor. The relevant Tasmanian minister had informed the Commonwealth of the proposed action. They were of the same political persuasion, but also said it was not referring the matter to the Commonwealth as it did not consider that the proposed action would have any impact on the values of the protected area. And the Commonwealth, perhaps with an eye to its political fortunes in the relevant area, did nothing. The case is reported both at first instance and on appeal. Tasmanian Aboriginal Centre Incorporated against the Secretary, Department of Primary Industries, Parks, Water and Environment, number 2, 2016, Federal Court of Australia 168. So under the Epbc Act, the Commonwealth often imposes conditions on approval, but the enforcement of these conditions is sporadic and relies on a cooperative approach. We're not talking about fisheries returns where a statement is submitted. This kind of cooperative conditional enforcement is inadequate where large sums of money are at stake and the temptations to cut corners are real. The Samuel Review into the Epbc Act found the compliance and enforcement powers in the Epbc Act are outdated. Powers are restrictive and can only be applied in a piecemeal way across different parts of the Act due to the way it is constructed, the complexity of the legislation, impenetrable terminology and the infrequency with which many interact with the law make both voluntary compliance and the pursuit of enforcement action difficult. Strong, independent compliance and enforcement is required. Independent compliance and enforcement functions that are not subject to actual or implied political direction are needed. The functions should be properly resourced and include a full toolkit of powers and systems. So in cases in which environment groups undertake litigation to uphold the law, whether under the Epbc Act or under other legislation, those groups are required at great expense and personal risk to go to court when it's usually the accepted role of the state to take action to enforce its laws. Community groups often find themselves opposed to the resources of government, applied not to uphold the law, but for political ends. Where corporate interests are involved, as is usually the case, the corporate parties have the benefit of tax deductibility for their legal expenses, which is not true for community groups who are acting for the public good. In many cases, the risk of adverse costs orders means a real risk of office holders of these organisations losing homes and other assets, and that's an extraordinary burden to impose on citizens. The implicit model behind this is that the government sets out some broad aspirational principles and then steps back to let those who might be referred to as stakeholders fight it out. There's no level playing field. This is stacked in favour of those with the resources to litigate and with the right political support. But if that's the model, do our environmental laws really amount to laws as most people would understand them? It's not enough for governments to espouse environmental values in legislation without establishing its own mechanisms to enforce those laws. We do have a systemic problem at both state and federal level, perhaps at local government level too, in which powerful interests are able to circumvent environmental laws and governments have not put in place adequate independent means of enforcing those laws that they've enacted. The rule of law is one of the fundamental tenets of liberal democracy. Australia's traditions as a democracy depend on our adherence to the rule of law. This doesn't just mean having laws and requiring people to obey them. Even tyrants have laws. The rule of law operates as a check on the arbitrary exercise of power. It's about the independent oversight of the exercise of power. Governments and corporations, like citizens, must be accountable under the law. The law must be clear, well known, and applied without fear or favour. Having laws to protect the environment that are only sporadically and unevenly enforced undermines not only the environment, but also, I would argue, the rule of law and our democratic traditions. So we should be astute to ensure at all levels of government that laws to protect the environment don't merely espouse values in a general way, but have specific enforcement mechanisms that give them teeth. And I think that protecting the environment is too important for us to accept anything less. Thanks very much.
Thanks very much, Brian. I can't see any questions that have come through on the chat function, and we do only have about 4 minutes left, so we might not go with any questions for the moment. Thanks so much for speaking today, Brian. I was particularly interested in the way you linked the enforcement of environmental laws with the administration of justice and the rule of law, because I think often those things are remarked upon in relation to other areas of the law, and they also ring true for the administration of justice in the environmental law realm. I was also interested in the points you touched upon about effective mechanisms. For example, you comment that filling in forms in the form of a declaration and being dishonest on a declaration is something the law already understands more generally. So it can be an effective mechanism provided it's enforceable or provided it's enforced. I hadn't realised this issue around the invalidation of other acts and permissions by the provisions of an act. I think you mentioned that in relation to one of the Vic Forests cases, and provided you can get that into the environmental law, then it seems like a very good mechanism to make sure that there is some reasonably automatic invalidation of acts which contravene the environmental law itself. So all in all, very interesting discussion. Thanks so much. And on behalf of NELA and myself, I'd like to extend a vote of thanks to you today for speaking, and would you all join with me in congratulating and thanking Brian?
Thanks very much.
I'll hand over to you again, Hannah.
Thank you, Tiff. And I'll just acknowledge Tiff for proposing Brian, who was a wonderful presenter at this AGM. It's so frustrating and very saddening that our governments don't respect legal judgments and act to protect the environment. There's data coming out of Denmark about levels of trust in government and why it's so much higher there. Our trust in government is very, very low, and Brian's presentation gave many examples of, regrettably, why that is so. There's legion literature on the lack of economics of the native forest industry in Australia, yet decades and decades on, we continue native forest logging, which is just heartbreaking and devastating for our biodiversity. And climate, you know, we're chopping down our climate sinks. Why do we do that? So Brian, thank you very much. And Tiffany, thank you very much for organising Brian to be our presenter. That concludes our AGM.